rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. All right, this is the time set for oral argument in the matter of Arizona Advocacy Network Foundation et al. Versus the State of Arizona, our civil number 19-0489. This is one of our first in-person arguments since the Chief Justice changed issued the latest administrative order concerning operation of courts. So we're still trying to figure some of this out. You'll notice I've removed my mask. Counsel are free to remove their masks at their option. Certainly, we'd ask that when you do argue, you remove your mask, but it's up to you as to whether you wish to keep it on otherwise. I understand that counsel has a suggestion on how to operate these clocks so that you can see them, even though you won't be at the podium. So when as I understand the suggestion, when the appellant is arguing, we will run the clock, appellee's clock, and you will be able to see it. And similarly, when appellees are arguing, we'll run the clock designated for appellant. So you guys are on board with that. All right. Very good. So each side will have 20 minutes within which to present their arguments. Here today, appellant may reserve some portion of that for rebuttal. It's up to you as to whether you wish to do that, and also to keep track of your own time in that regard. We have read the extensive briefing that has been submitted in this matter, and we have conferenced the case. So we're familiar with the underlying facts, although I suspect we are not as keenly attuned to some of the nuances as the parties will be talking to us about, so we appreciate that. All right, with that, appellants may proceed.
May it please the court, Timothy Berg and Emily Ward of Fenimore Craig, on behalf of defendant appellant State of Arizona. I would like to reserve 5 minutes for rebuttal. While the commission and to an extent the plaintiffs paint this appeal as an unremarkable one about narrow issues arising from what they call a narrow judgment with respect to a portion of the state's election laws, it is much broader and more significant than that. At issue here is the impact of the Voter Protection Act on statutory provisions that are not themselves contained in a statute that is VPA protected, but which are incorporated by reference into a VPA protected statute. And this is an issue that goes beyond simply the state's election laws and applies to any law in the state that is subject to the VPA. Commission and the plaintiffs want this court to dramatically broaden the VPA's limitation on the legislature's authority in a way that could not have been contemplated by the voters when they adopted the VPA. What's at issue here really is whether there's an impermissible implied amendment of the Clean Elections Act, which is Article 2, Chapter 6 of Title 16, when the legislature amends other statutes, either in Title 16 or otherwise, that are incorporated by reference into the Act, into Article 2. There really are two kinds of, the first thing to remember is, as a threshold matter, the VPA only applies to a statute that amends, supersedes, or repeals a VPA protected statute. So the VPA has a limited scope. In order for a new statute to be subject to the VPA, it has to do one of those three things to a VPA protected statute. I don't think the issue before the court really has to do with either whether the statute is superseded or repealed. It's a question of amendment. There really are two kinds of amendments, one of which isn't at issue here, I think, or at least not significantly, and that's a direct amendment. And a direct amendment.
Let me ask a question in that regard, because with one of the definitions, it is repealed. There is no definition of political contribute or committee anymore. Is that a repeal? Because now where do the voters look, or anybody look for that definition?
Your Honor, I don't think it's a repeal. It's not a direct repeal because it's not an appeal of the statute itself. To me, a direct amendment or direct appeal would be you go in Article 2 into the Clean Elections Act itself and change something in it or pull something out of it that's directly there in the words.
But if we were to extend it the way the commission wants us to in Arizona Advocacy Network, it would actually be a repeal, wouldn't it?
I don't think so, Your Honor. First of all, recognize the limited scope of political committee in Article 2. There really are, as we point out in our briefs, only two things. One says that somebody can't do certain things if they're a member of a political committee, and the other has some minimum requirements. Political committee
But
is in no way...
just for argument's sake, it doesn't matter if it's important or not. If it is an amendment, it's an amendment, correct?
Your Honor, I do think that it needs to be a substantive change. I think it is a perhaps more interesting and tougher question.
And that's
whether
why
you can make
tease that out. Tell me why
whether you can
that
make,
fact that definition is gone, that's okay.
I think it's gone because, and it's okay because what you did was incorporate a provision of another statute. And when you do that, whether you're the voters or the legislature, you do that and make it subject to the fact that that definition can change later. If you look at the Brain case, the Brain case said you get X percentage of a formula, from the X percentage of what someone else gets, you get. And the legislature then changed the bottom line number, the number against which you applied the percentage, the permissible amount of contribution. And the answer was that didn't violate the Voter Protection Act because when you incorporate something else, you incorporate it subject to the reality that the legislature may choose to change it.
I agree, but what happens when the legislature chooses to just eliminate it? That's different. A change is one thing, elimination is another.
I don't agree with that, Your Honor, but I think that's certainly a line the court could draw. What you could say is, in this case, the changes to the definition of contribution or expenditure are fine under the VPA because you incorporated a definition, you took what it is, it's been changed by the legislature, and now you live with a new definition. The legislature can't eliminate a definition. Again, as a practical matter, it has very little impact on the VPA if that is eliminated. And certainly there seems to me to be an argument that it's a risk you run when you incorporate a definition that it'll either be changed or eliminated.
Let me ask you about the first two definitions, contribution and expenditures. The Brain dealt with a formula. Are the definitions of contribution and expenditures actually variables in a formula for determining contribution limits?
They are not variables in a formula. They in fact define part of what goes into the formula.
Doesn't that make it a variable? Just like the
perhaps it does, Your
definition
Honor.
of the dollar amount that was amended in Brain, it defines what the dollar amount is.
You could be correct, Your Honor. You could look at this and say that what contribution does is give you one factor in that formula, one variable factor in that formula, and therefore, in addition to the fact that it's variable because it's only been incorporated by reference, it's variable as a variable in that formula under Brain. I think that's exactly correct. When you get to the question of an indirect amendment, I think you have to look at the question of what's been amended and how. If you look at what's amended here, what is largely at issue, setting aside one issue related to enforcement, are definitions that the drafters of the Clean Elections Act chose to incorporate by reference. Having done that, they run the risk that the legislature will change incorporation by reference. If you take plaintiff's argument to its extreme, we make this point in our brief. At some point in the Clean Elections Act, it says you can use an electronic signature as defined in whatever the statute number is that defines electronic signatures, generally for the law in Arizona. We have an Electronic Signatures Act. If you took Mr. Barton's position literally, you could not change the definition of electronic signature in an entirely separate statute that had nothing to do with elections, simply because the voters chose to incorporate that unrelated definition into Article 2 into Article 2 into the Clean Elections Act. That can't be the law. The voters can't have intended to say, when we adopt the VPA, we are not only protecting statutes that we as voters adopt, we are freezing all sorts of other statutes that are unrelated to the act the voters adopted, except they happen to be incorporated for convenience because the state wants one definition of electronic signature, or because it's easier to incorporate than it is to write out. In the court below, the commission made a slightly different argument that I think is on its surface more intellectually appealing, but ultimately takes you to the same kind of dead end. If you take as a given that the plaintiffs can't be right, you can't absolutely freeze every definition incorporated in there, including ones that have no real purpose in the statute. You end up in the position that the commission argued below and argues somewhat here, but not as much. And that is, okay, you can change an incorporated definition, whether it's in Article 1 of the election statute or whether it's the electronic signature definition. But that definition is changed only for the purpose of the statute that you're changing it in. It doesn't change for the purpose of Article 2, the Clean Elections Act. What's the problem with that? I think as we point out, and as Judge Gorsuch pointed out, Justice Gorsuch, then Judge Gorsuch pointed out pretty well in the El Encanto case, that creates a different kind of problem, a trap for the unwary. The purpose of the election laws ought to be so that candidates, election committees, citizens can understand what the law is. If you follow the logic of that position...
Isn't that stand true on your argument as well? Because now we have a reference to a definition that no longer exists. We're making changes to statutes so that the J through M exceptions that are identified aren't, I think it's in 905, they're no longer there. So under your argument, the same thing happens.
No, Your Honor, because under my reading of the statute, you can go read Article 2 and it will tell you, go look at this definition in Article 1, and it's the definition you apply. But under Mr. Roth's reading of the argument, it says contribution is defined here, and it's not the correct contribution. You have to go back and look at a previous version of the statute.
Well, how do you find the exceptions J through M that are referenced? Again, I believe it's 905, and I'd have to flip through my notes here. When the legislature has, because of taking the position that just because it's referenced in the Clean Elections statute, it's not protected. So now anybody looking at that statute has to go back and look at the old versions to figure out what the J through M exceptions are.
I don't believe that's correct, Your Honor. I believe what you can do is look at the current version of the statute. Now, it may not be in the same place. I will grant you that it may be a little more difficult.
Isn't that the exact same problem that you're talking about?
No, because it's there in the statute. It's in the current version of the statute. What Mr. Roth would have you do is go back and look at a previous version of the statute, the 1998 version of the statute, which would tell you what the law is. And that can't be correct.
But is the quagmire any different? When you say, okay, you got to go back through the history, find what was J through M 20 years ago, that's the one that applies, as opposed to not having a definition. I don't see how the quagmire that you talk about is any different.
I think the quagmire is different, Your Honor, because a citizen or lawyer can sit down with the current version of ARS that's on the state legislature website or on the court's website or wherever else you find it, and the current version of the statute that applies to that candidate is there. If you adopt Mr. Roth's view, you go there and it is, Your Honor. You go there and it's gone. And in Mr. Roth's view, you have to go back to 1998. Now, there's a problem with that.
How do you find what was J through M in 1998 if it's no longer J through M now, except to do exactly what you're talking about?
But you
go
don't
back to the 1998 version.
You don't need to, Your Honor. all you have to do is look at the current version of the statute and follow it.
But J through M is no longer J through M. So if I take the cross-reference to J through M, in fact, it doesn't even go through M anymore. I can't follow that without doing a statutory history.
Your Honor, that is why I believe that originally the statute as it was proposed would have changed those cross-references. And the part of the statute that didn't go into effect was the part that would have changed those cross-references in
understand.
Article 2. Again, because the decision was made by the legislature that that was a Voter Protection Act issue and that they weren't going to change the actual language in Article 2 to fix that problem.
And exactly the point. And because they didn't do that, the same difficulty with trying to figure out the statute is created on either way. And we can move
Again, Your
on
Honor,
if you disagree.
Again, Your Honor, I
believe-
disagree because I think when you have it there in front of you, you can sit down and read through it and figure it out, where you have to go find a previous version of the statute to make sure you found the right one. I would suggest to you that's more difficult. Maybe we just can't agree on that, but that seems to me to be a bigger burden to put on a citizen to say, not you have to read what's there on the website and understand it and figure it out, but you've now got to go find something else and read it and figure it out.
And
So-
either way, it's a burden the legislature put on the voters to do that.
So Mr.
Go
Bergen,
ahead.
because of the time constraints here, could you address the enforcement
Yes.
issue?
Your Honor, if you go back and look at the statute, what the statute says, sorry, I'm trying to turn to the language of the statute. What the statute basically tells you is that that the Commission has the authority to enforce Article 2. It has authority to enforce the Clean Elections Act. It has authority to monitor reports filed pursuant to this chapter and financial records as needed to ensure that money required by this article to be paid to the fund is deposited in the fund. That's not a general authority to enforce Chapter 1 of the statute, or Article 1, I'm sorry, of Chapter 6 of the statute. What the Clean Elections Act has is the ability, first of all, it has the ability to enforce. What the statute changes is who investigates. The filing officer investigates. The Commission still has the authority to enforce what it ever had to enforce, because what the statute says now is that it is the filing officer who investigates violations of Article 1, and the Commission has the authority it always had to enforce Article 2.
So the commission is totally dependent upon a third party to do the investigation, and their enforcement is limited to that, the findings in that investigation?
No, Your Honor. I think the difference is the filing officer is entitled to investigate Article 1 violations. The Commission is entitled to enforce and presumably investigate Article 2 violations. There's a clean division of the statute. Article 2 is the Clean Elections Act. That's what the Clean Elections Commission enforces. That's what I'm reading, ARS 16-956A7. And what that says is that the Commission has the authority to enforce this article, meaning the Clean Elections Act. That's what their enforcement authority is.
And that doesn't presume the right to investigate?
It presumes the right to investigate violations of Article 2, not violations of Article 1. And what they're complaining about is something that says the filing officer is the only one that can investigate violations of Article 1. So I don't think it creates a logical problem at all. It's a jurisdiction problem. It's a division problem. Who enforces which article? And the answer is it is the filing officer, who is usually the Secretary of State, but not always, who investigates and frankly has the Attorney General then enforce violations of Article 1. It is up to the Commission to enforce Article 2.
And I don't want to take up too much time of your bottle, but just very quickly, then if the participating candidate has to file an affidavit certifying compliance with all Article 1 violations, and if the participating candidate violates that, isn't that an Article 2 violation that they should be allowed to investigate, use their subpoena power and everything that's been given to them to do that?
I think, Your Honor, if a participating candidate violates Article 2, the commission is entitled to investigate that.
If they suspect it even.
If they suspect it, yes, obviously.
And if a non-participating candidate were to violate the contribution limits under Article 1, that would be a violation under Article 2, because they would spend too much and they would be subject not just to the penalties, but potentially removal from office. And that would then be something that they can investigate, wouldn't it?
No, I don't agree, Your Honor. What it says.
So how do they investigate a violation for exceeding the expenditure limits?
What the statute does is create, I think, a clear division, and clearly these folks don't. But Article 1 is administered by the Secretary of State and enforced by the Attorney General. Article 2 is enforced by the Clean Elections Commission. If the Clean Elections Commission thinks there's a violation of Article 2, it can enforce it. What it can't do is separately go out and enforce something that is only a violation of Article 1. Trying to save a little bit of my time for rebuttal. It's clear that that answer didn't satisfy you, and I'm sorry, Your Honor.
That's all right.
I guess I'll save my last minute 22 seconds for rebuttal.
All right, Mr. Berg, because we've hounded you with questions, I'm going to give you an extra 3 minutes.
Thank you.
For rebuttal. We'll give Appleese an extra 3 minutes as well. Be fair about it. All right. Assuming our keepers of the clock can keep track of that, we're doing well. All right. You may proceed.
Good morning, Your Honor. It's Joseph Roth on behalf of the Arizona Clean Elections Commission, and may it please the court. If it is okay with the court, the plaintiff appellees have been so gracious as to allocate half of the time to the commission for the argument in favor of affirming the judgment below. I intend to keep to that 10 minutes and hopefully give back more. All of the 3 minutes certainly helps. And I intend to primarily address the issue we just left, the enforcement issue, and leave to Mr. Barton the definitional issues, although of course I'm happy to answer any questions that the court has or depart from that plan, but that was my plan. Okay.
So could you repeat how the definitional agreement issues?
I intend to leave to Mr. Barton the definitional issues. Happy to address any questions, though, particularly as it pertains to the arguments the commission made in its brief. But before I get to the specifics of the 16938A issue, I think it's important to start where Mr. Berg started with a framing problem as the commission sees it. The state's framing of the issues for this court are incorrect in at least 2 significant ways, and it runs throughout the briefing, and it was heard today in argument. First, the state contends that to affirm this judgment, the court needs to conclude that the voters who passed the Clean Elections Act intended to freeze, or they use the word enshrine in the briefing, the law as it existed in 1998, or that the other option is that the court should reverse and allow these provisions of SB 1516 to go into full force, including as to the Clean Elections Act. This is a false choice for the court. The application of the Voter Protection Act does not freeze the law. The law can change, and a voter can reasonably anticipate that the law could or would change in the future. But the voter would also reasonably anticipate that any changes would comply with the Constitution. Just as a default, a majority vote must be obtained when a law modifies, amends, repeals, supersedes a voter-protected act. It has a different set of procedural requirements under the Constitution. The legislature has options. They can pass a law in compliance with the VPA. They could also pass a law and refer it to the people for a vote, as they did in the 2018 election with Prop 306 that amended the Clean Elections Act after the voters voted on it. What they can't do is ignore those procedural requirements any more than they could ignore the 50% plus 1 requirement. Judge Winthrop, I'm sorry, did I cut you off? Okay. The second framing problem is also what we heard today, that the state wants the court to believe also that affirming would also require the court to say that the VPA prohibits changes to any provision that is merely cross-referenced, and that this case is really about the outer reaches of the VPA. That is not the commission's position, and that is not the question for the court today. The issue here is whether the provisions of SB 1516 amend the Clean Elections Act, whether directly or indirectly. The case asks the court to apply the plain text of the VPA to an ordinary question of textual interpretation of whether an amendment occurred. If there is an amendment, the analysis stops there. The VPA requires a supermajority vote, and 1516 did not obtain that. So questions about whether these changes further the purpose of the act are not for the court to decide today. And turning to the specific provisions, here the enjoined provisions clearly do amend the meaning of the act, and the meaning is altered directly, the words are indirect. But turning to 16938A specifically, and just looking over at the clock that we have here as well, the injunction prohibits one phrase of one clause of one sentence of SB 1516, that the filing officer for reports under Articles 1 and now what's 1.1 through 1.7 is the sole public officer who can conduct investigations, not only conduct investigations, but trigger enforcement, because enforcement cannot occur unless the investigating officer refers it to the enforcing agency. This provision amends the Clean Elections Act for at least 3 reasons. 1, it removes the authority of the commission to choose when and how to enforce part of the Clean Elections Act. And this was ignored in the presentation earlier. The 16942B, which sets out certain penalties for certain violations, authorizes the commission to impose penalties for certain kinds of violations of any reporting requirement in this chapter. And this chapter is Article 1 and Article 2. Number 2, this change to 16938A, it removes the authority of the commission to investigate, as has been discussed, including through the use of subpoenas, a power that the Clean Election Act grants under 16956B. And number 3, it removes the commission's authority to decide whether to commence an enforcement proceeding at all, because under 16957, which lays out the commission's enforcement process, the commission is supposed to find whether it's reasonably likely, a reasonable probability that a violation occurred. If the commission finds that, it may start an enforcement proceeding, and it may impose penalties under 942, including those penalties for reporting violations that fall under reporting requirements of Article 1. How can the commission find that a violation might exist if it also does not have the power to investigate whether it occurred, including through use of subpoenas?
And let me ask you, does that also stand true because the commission's allowed to receive outside complaints? So how does that factor in, and is allowed to act on them as long as they're filed timely?
Yes, that is another mechanism that 16957 provides for the launching of an enforcement proceeding, but not the only.
Let me ask you this. What is it that the commission has investigated up till now that you believe it won't be able to investigate after the act?
Well, for example, I don't have a specific example in mind. It's been a conservative in its enforcement approach over the years. But the commission is, as Mr. Berg noted, obligated to monitor reports. If it sees what looks like might be a violation, it can surely subpoena records regarding that, seek information, and make a conclusion at an open meeting that leads to an adversarial process about whether or not there was a violation, whether penalties are appropriate under the procedures set out in 16957. Under the new provision in 938A, that responsibility about the investigation and whether to refer the matter for enforcement is now the filing officers, a third party, not the commission. That referral also triggers an entirely different enforcement procedure with different timelines and different restrictions on the agency's rights under 938E than exists under 16957, another change to the Clean Elections Act. This is a surgical removal of part of the commission's enforcement power, and it cuts at a core purpose of the commission to serve as a separate bipartisan appointed entity that can administer the Act's campaign finance reforms without undue influence from elected officials. But regardless of whether it's good policy or bad policy is really not the point. It changes the meaning of the act. That means that the Voter Protection Act must be complied with, and that did not occur here. So the legislature has a choice, can comply with the VPA, refer the matter to the people, but it may not ignore both of those options and pass it without a supermajority vote. The state's response, some of which we heard, some of them in the briefing, each of them fail. One thing to note, we heard talk of brain. Brain cannot save the argument here, and it's not asserted by the state. So they have to explain why this change to the commission's pre-existing enforcement authority is not an amendment to the Clean Elections Act, and they can't. The first argument and the primary argument is the one we heard, that under 16956A7, the Commission's authority to enforce is restricted to Article 2, because it says the Commission shall enforce this article. But that argument fails very quickly when you analyze the text of Article 2, which, as we've said, explicitly incorporates certain violations of any reporting requirement falling under Article 1. That is part of the Article 2 enforcement authority that the Commission has. So the reference to that language in 956A7 is not a reason. It doesn't explain why 938A doesn't amend the Act. Mr. Berg said that he thinks that these statutes create a clear division between Article 1 and Article 2. The way I see it, I agree that the new language in 938A7 does purport to make that clear division, but if that change is to be made, it must comply with the VPA or be passed by the voters. Number two in the briefing.
Is it the Commission's position that it has basically dual jurisdiction then to investigate any Article 1 through now 1.7 violation, or does it have to tie in somehow to a violation of the Act as it's doing its investigation and enforcement?
Well, the only authority to impose the penalty is for a certain kind of violation of a reporting requirement under Article 1, which is a violation of reporting requirement by or on behalf of a candidate. And the other part, as you noted, Judge Goss, is that the Commission surely has authority to observe Article 1 contribution limits and assess whether an egregious violation has occurred that might cause the penalty under 942C, which includes disqualification or forfeiture of office. I see that I'm using my time up here, and I want to honor my promise to Mr. Barton, and so I would like to leave it there unless there are some other questions from the court.
Oh, thank you, Mr. Roth.
Thank you.
Good morning, Jim Barton of Torres Law Group on behalf of the AZAN and the legislators. I want to start by talking about an enforcement that I think is relevant to this question about when have they enforced based on Article 1. And there was an example of a case of a 501c3 that was doing expenditures that they believed to be voter education, and actually not voter education, they believed to be constituent education. That would be an appropriate expenditure of funds. The Clean Elections Institute or the Clean Elections Commission said, no, we think that's express advocacy and we're going to investigate because this is an independent expenditure. The rules about what is and is not express advocacy is in Article 1. The rules about whether the committee has to register is in Article 1. That's where you go to find the core substantive material. But the Clean Elections Commission was authorized to investigate that because currently the Clean Elections Act compels them to take reports for independent expenditures. It compels them in 16942 to investigate any reporting requirements or the burdens that have been placed on by anything in this chapter. So again, that references back. So the question would be, if you really said that you could only have, the commission is now removed from its authority to investigate under Article 1, that investigation of that organization that was a C3 making what the commission, I'll be honest with you, I was their lawyer, I disagree with the commission, but the commission determined that they were independent expenditures, that power would be taken away. So that's an example.
Let me ask you, because the commission, the report that has to be filed under 958, I mean it's C or D, whichever it is, that if there's any payment made expressly or not expressly advocating, that's not the language actually, I don't think in that section, for a candidate, they still have to file that report, notwithstanding whether they're a political committee and whether those things apply. Isn't that true?
Well, Your Honor, they have to file a report if it's express advocacy. Because if it's not express advocacy, if it's issue advocacy, if it's just telling the constituents about what their elected official is doing, which is the position of the C3, that doesn't get disclosed anywhere because that's issue advocacy. And it wouldn't trigger the language in 58 that says if you exceed an expenditure limit that was set earlier in 942 or 941, then you have to go back and now make these other what we call trigger reports. If the expenditure is an issue advocacy, which was their position, then it doesn't get disclosed anywhere. But instead, the commission in this case said, no, we disagree with you. We think it is not issue advocacy. We think it's express advocacy. And in doing that, they were referencing 16-90101, where it defines what express advocacy is. So
But express advocacy isn't in the act, is it?
express advocacy is not in the Clean Elections Act.
And so that's my point is the commission isn't limited to the definition of express advocacy, really. It's the words that are in that particular subsection. And I apologize, I'm not finding it right here, but the independent expenditure enforcement authority and reporting requirement under the act isn't necessarily tied to whether or not they need to form a committee and create a committee. They would still be subject to the reporting.
If it is express advocacy. So in other words, you're right. The independent expenditure requirement does not tie to them creating a committee. That's correct. However, whether you call it an independent expenditure, in order to when you're trying to figure out the four corners of whether this thing is or is not an independent expenditure, you have to go to Article 1. Under 938, they're not allowed to enforce things under Article 1. Only the filing officer is. So I think that's an example of where there would be an enforcement that would be taken away from them by 938. I also want to talk about two sort of special cases of where, when the voter said that they wanted to prevent that, it says in 940 that their concern was elected officials accepting large campaign contributions. I want to talk about how that purpose of the act is undermined by 1516. And the point here is that 16941, so that's a part of the act, says in A, it limits the contributions that anyone can take, participating or non-participating candidate. And then, the first one is A tells about participating candidates, B tells about non-participating candidates. B is the one that tells you about the 80%. So when we have, I'm sorry, just let me get my clock on here too. So when we have that situation there where we have a limitation on the contribution, it's based on the understanding of contribution at the time that the act was passed. And contributions then, as now, include in-kind contributions. In-kind contribution means I'm not giving you cash money, but I'm doing something for you I'm giving you something of value that's other than cash. All right. One way that you have an in-kind contribution then, as now, is if you do an expenditure and you coordinate with the candidate, that amounts to an in-kind contribution, right? If I work with the candidate and we design the ad together and we design where it's going to run and we talk about it and I tell you the budget and we all do that, and then I just happen to be the one who writes the check to the TV station and to the designer, that's still a contribution. It's an in-kind contribution. There's now, though, under 1516, a huge loophole, which is as long as I mediate my in-kind contribution through the political party, it's unlimited. It's unlimited. So this is an example of where, as the court below said, the nuts and bolts.
Isn't the issue before us, and this is what your co-counsel said, it's really not how far and does it further the act. The issue is whether or not it's an amendment. And we have to focus on that.
Thank you, Your Honor.
So let me ask you this. Under Brain, they said if it's part of a formula, it's not protected. That is the essential holding. I asked counsel for the state, how is it not part of a formula to define what a contribution is? And I'll give you the example, very first grade example. How many pieces of fruit are in the room? And you have 3 tomatoes, he has 2 apples, I have 2 oranges, and counsel has 2 lemons. And if the definition of fruit doesn't include tomato, then we count it differently. And that's a variable in the formula to how many pieces of fruit there are. Isn't that the same with what's a contribution? What are we going to count as a contribution? What pieces of this go in that, for lack of a better term, fruit salad that we've created that is a set of contributions?
It is not the same, Your Honor, because in Brain, actually what the court said was that they used the fact that it was a formula to intuit the voter's intent. So it wasn't just that. I agree with you that we can really, if you took a sentential logic class, you could write almost every law. You could write it out using the A's and if, ands, and buts, and you can make everything into a formula, right? But I don't think that's what the court in Brain said is the reason why. It's not because you could push it into a formula context. It's because it was numeric. It used 20% reduction. It suggested, because you had a system where you say it's 20% less, that the voter's intent could have been, I'm accepting this is going to vary. I'm accepting this is going to go up and down, and whatever the legislature says, it's going to be 20% less. That's what the voters could have meant. In this case, when we're talking now about these in-kind contributions, a whole variety of contribution that has been removed from regulation as long as it's mediated through the political party. That is a radical amendment to 941A and B because it radically changes what is regulated. It totally eliminates, when you were talking about before, it totally eliminates the limit on this one particular type of in-kind contribution. And I do not believe the court can look at the language of the Clean Elections Act and intuit from that the citizens intended to let the legislature change the contribution limit in any way, that they wanted to let all cash contributions are okay, or all contributions using checks are okay because now they're not defined as contributions. That cannot be taken from the voter's intent. The court in Brain was looking very specifically at, could you read it that way? This is more akin, honestly, this is more akin to what we saw in Maestas, where the court said, look, what was legal is now illegal. This contribution, this huge in-kind contribution before 1516, the Clean Elections Act made it illegal.
But that's
1516 makes it
Brain.
legal.
The amount increase was illegal before Brain. After that act went in, and the change in the amount that was no longer illegal. So a contribution to before 1516 was not allowed, but after 1516 it's the same thing. And Brain specifically said these are word problems. They didn't say it's a math problem; it's a word problem.
Yes, Your Honor, but they used it like a math equation. And when you say the amount, that's really important. You said the amount changes. And what the court found in Brain was that this 80% or 60%, or 20% reduction, 80% up, that set up a system where it looked like the voters could have intended to do the math problem. They could have intended for it to be a variable. By the nature of the phrasing, the court was able to intuit that they intended to leave it up to the legislature to change. I don't think you can see that same thing when you completely eliminate regulation of this variety of in-kind contribution. That's a different species.
What happens to the other changes in the definition of contribution that aren't in this matter? The meals, the things like that. Are those allowed if we were to rule, or what happens to them if we rule in the way that you're talking about?
Your Honor, they are those things that were not a part of the judgment, that didn't end up in the order. I mean, I think that the answer to that is they stay in effect. The new rule would stay in effect until someone successfully challenges it. It wasn't challenged. I don't think that it's been held one way or another. So I think there are other changes to contribution that are not before the court that perhaps would be dealt with in a future proceeding.
But if we were to rule in your way, they would be eliminated. I don't know how they would not be, because your argument is there can be no change to the definition of contribution because it is incorporated into the act.
That's right, Your Honor. I believe it would not be strictly speaking changed because it's not in the judgment that would be affirmed, but I understand your point.
What are the limits to that? Because, we have the references to a lot of different things, including the 14-day, 21-day, whichever it is in Title 12. What do we do with that? I mean, is that now voter protected as well? And unless the legislature has the requisite votes, we can't change the limits? I
think the limits are what we have from the Cave Creek and the Brain cases. What's the voter intent? So did the voter intend it? There are some things that maybe you'd say, well, the voter really didn't, this language isn't intended to affect that other matter. I think another limit is.
But how do we know that? Just if it's referenced, it's referenced. And you're saying if it's referenced here, then it's a mere reference of are defined in. I don't know how we limit it.
I think when you look at the court's ruling in Maestas, which said you can't say, well, we're going to change the definitions of what's an exception. We can't, you can't, that was not okay. And then the court said in Brain, you can change the contribution. I think what that's telling you is it's not a black letter law test. It's going to be easy. I think you have to look at the whole context of the statute. And if you look at the whole context of the statute here, I don't think that you can possibly say that the voters intended to leave this.
But Maestas was about superseding, not amending. And so it's a superseding case. And so that's a different matter altogether, isn't it? Then if a definition were to supersede the act, we would be looking at it differently, wouldn't we?
I think it would be intellectually different because superseding is different than amending, but I think the rules would be similar. I see that my time is out, and so I didn't get a chance to talk about the C4s. It's in the papers, but if you would like for me to talk about that, I can, but otherwise.
We'll we'll trust your briefing has covered it.
Thank you.
Mr. Berg, your rebuttal?
Briefly, Your Honors, I'd like to go back to the incorporation by reference issue because I think that's really, in many ways, the most important issue here. Mr. Roth wants you to think this is simply about a test you apply only to a limited number of sections, which Mr. Barton thinks are incredibly important and Mr. Roth seems to think are relatively trivial in the Clean Elections Act. But the question here isn't what does the Clean Elections Act mean? It's what does the Voter Protection Act mean and what does it do? And if this court adopts a test for that, it's going to be applicable not just to the Clean Elections Act, but to other voter protected acts. With respect to incorporated definitions, you really have three choices. One is the position Mr. Barton argued in the Superior Court, which is once you incorporate a definition into the Clean Elections Act, it is frozen for all purposes and for all time, unless it's amended, as Mr. Roth correctly points out, by getting a 3/4 majority and is viewed as consistent with the purposes of the act. His alternative position seems to be, no, you decide how important it was, and if it's important, it's frozen, and if it's unimportant, it's not. I suggest that's a test that is fairly standardless and is going to lead to lots more litigation. And again, it's not the right answer for some of the same reasons as the first one. You have Mr. Roth's position in the trial court, which is, no, the incorporated definition can be changed for the statute that it's in. So you can change the definition of contribution for purposes of Chapter 1. You just can't change it for purposes of Chapter 2. And Judge Gass and I have talked at length about what I perceive to be the problems with that. The third choice is the choice we're offering you. And that is a choice which says, when you incorporate a statute by reference, you incorporate it recognizing that the legislature or the people can change it at some point in the future. And that's really, if you read Brain, what the Brain Court concluded was that
Would you concede on your argument, though, that if the definition was changed sufficiently, it could become the Maestas supersede issue?
Yes, Your Honor. There is a line at which I think Maestas says you can't change the substantive provisions of the act indirectly if you couldn't change them directly. And I think that's different from saying if you incorporate a definition into an act, you can't change that definition. Is there a point at which the changing of the definition could be so extreme or could be a subterfuge for doing what the court was doing in Maestas? Perhaps that's not the issue you have in front of you today. At the end of the day, you're going to have to come to a way of reading that, of one of those three approaches. Because when a legislature goes and changes an incorporated provision in a VPA protected act, there's got to be a rule as to whether that works or not. And while Mr. Ross says to you, you don't need to get there, you have to, because that's really the primary issue in this case is, could the legislature have changed those definitions when they're not actually in the VPA? Very quickly on enforcement. As we point out in our brief, first of all, prior to 1516, there was additional provision of the act that expressly limited the commission to enforcing Article 2. And I don't have the reference in front of me, but if you look in I think it's our opening brief, it's there. 2, if you look at the statute Mr. Roth relies on, 942B, it talks about additional penalties. That doesn't suggest that the commission has independent authority. Again, if you look at the statute, what the commission enforces is Article 2, not Article 1. That was clear in the statute before 1516. It's clear in the statute after 1516. And even if you were to invalidate 1516, then you go back to the law before that. You don't go all the way back to 1998. I don't often agree with Mr. Barton, but I do on that. The judgment here, if you affirm it, doesn't invalidate provisions that Mr. Barton or Mr. Roth's clients didn't choose to challenge in the statute. Those aren't before this court. We ask the court to reverse this judgment and remand it with instructions to enter judgment in favor of the state because 1516 did not violate the Voter Protection Act. Thank you, Your Honors.
All right, thank you, counsel. Appreciate your briefing in this matter and your arguments and responses to questions here this morning. We'll take this matter under advisement and issue our decision, a written decision in due course. And with that, we are adjourned. Thank you.